Good evening. I'm Lynn Ensroth, for those of you who I have not met before, and I'm Dean of the University of Tulsa College of Law, and it is with great pleasure that I welcome you this evening to the Judge Stephanie Seymour Distinguished Lecture in Law. This lecture series was established by Judge Seymour's former law clerks who were inspired and shaped by their experience working for her. This lecture series not only recognizes and honors Judge Seymour's tremendous work and accomplishments with the 10th Circuit Court of Appeals, but it also recognizes and honors Judge Seymour's tremendous work in her chambers, where through her mentorship and wise counsel, she has trained and launched the careers of many of Tulsa and, in fact, the country's finest lawyers, some of whom are in this room with us this evening. The former clerk who spearheaded the creation of this wonderful lecture series is Janet Leavitt, who is the former dean of the University of Tulsa College of Law and currently provost of the University of Tulsa. Provost Leavitt credits Judge Seymour and her red editing pen with enhancing, honing, and developing her analytical skills, her writing, and helping her find her strong and important voice in the legal world. And as someone who's known Janet for quite some time, it is an incredible, you imparted incredible skills to an incredibly talented lawyer. But Judge Seymour does far more than just wield her mighty red pen to train her law clerks. She instills in her clerks the ability and sense of responsibility to treat all individuals with respect and dignity, remembering that the dignity of the rule of law is a worthy and important value to apply to all who come before the court. I am honored this evening that Judge Seymour and Provost Leavitt are here with us tonight, so please join me in welcoming them. In keeping with the values and importance of mentorship and support for those in the early stages of their legal career, the Seymour Lecture Series sponsors untenured faculty who are establishing their legal voice and role in the legal scholarship and academia. And truly, this is one of my favorite events and lectures because not only do we have interesting topics, but also we get to meet and hear from the rising legal voices in our country who share with us important, new, and provocative and innovative ideas. Today, we welcome Associate Professor Margot Kaminski of the University of Colorado, where she serves as the Director of the Privacy Initiative at Silicon Flatirons. Previously, Professor Kaminski taught at the University of Ohio, and she served as the Executive Director of Information Society Project at Yale Law School. She is also the co-founder of the Media Freedom and Information Access Clinic at Yale Law School. As her background suggests, Professor Kaminski specializes in the law of new technologies, particularly focusing on informational governance, privacy, and freedom of expression. She has written about drones and robots and AI and censor privacy in the Netherlands. In addition to publishing in distinguished law journals like the UCLA Law Review and the Minnesota Law Review, Professor Kaminski also publishes and writes frequently in the popular press on these cutting-edge issues. Tonight, Professor Kaminski will share her thoughts and insights on the use of algorithms in significant decisions that affect all of our lives here in the 21st century. Her lecture this evening is entitled Binary Governance, a two-part approach to accountable algorithms. Please join me in welcoming Professor Margot Kaminski to the podium.
Thank you so much, and thank you for that very generous introduction. Thank you to the judge for, almost on behalf of her clerks, for the amount of mentorship that must have gone into getting them to put this lecture series in place. I think only appropriately for a lecture series that is named in honor of a judge, I'm going to start with this sentence. Human decision-making can be seriously flawed. So we all know that humans are terrible decision makers. So if you did not know that humans are terrible decision makers, I hate to spend the first 5 minutes of my lecture disabusing you of some pre-existing biases. But humans as decision makers are subject to bias. They can be outright discriminatory, and we're subject to cognitive biases, and I'll explain what all three of these things are with some examples. So as an example of bias in human decision-making, there's a recent study by sociologists Rivera and Tilchik about something very of interest to people who are attending this lecture, the hiring practices of law firms. So they sent resumes to 316 offices at 147 law firms in 14 cities around the country. The resumes included fictional applicants in the top 1% of their class. They had identical employers and work history, and the only variation on the resumes fell into two categories. One was gender, so one version of the resume was James, the other version of the resume was Julia. And the second set of variations had to do with signals on the resumes that the authors of the study indicate social class. So if you look at some of these examples, some of them are more questionable than others, but it includes things like saying that you belonged to the sailing team instead of the track and field team, saying that you enjoyed polo and classical music as opposed to pickup soccer and country music. So, possibly unsurprisingly, the higher class man version of this resume had a callback rate that was more than 4 times that of the other applicants, and in fact was more than all other applicants in the study combined. So there's your stats. 16.25% of the higher class male resumes received callbacks, in comparison, surprisingly, to only 3.8% of higher class women who received callbacks. So in addition to these kinds of biases, which may or may not be intentional, humans are also discriminatory. I'm going to give you, for reasons I'll explain later, the example of historic redlining, in which banks decided to, and loan companies would draw actual red lines around neighborhoods to which they would not give loans. And those were often direct proxies for neighborhoods of a certain race. So this is the 1936 Homeowners Loan Corporation map of Philadelphia, indicating where the best housing inventory was, the declining housing inventory was, and the hazardous housing inventory, with hazardous inventory largely belonging to neighborhoods that were predominantly African American. Then the last sort of introduction about human decision-making and its problems that I want to give to you all, if you're not aware from any time you've spent with humans, we're not rational. Okay? We have a lot of sort of pre-assumptions that we carry with us that are distinct from bias and discrimination, though they can be connected to those things. For example, there's a cognitive bias known as anchoring. When you make a decision, you often tend to prioritize one particular fact over others for no good reason. That fact is often the first fact that you hear in relation to a particular problem. We suffer from confirmation bias. We're inclined to take in information and come out with the same conclusion that we had going into a problem. We suffer from the endowment effect, meaning that we irrationally value things more when we have them than before we get them. I like to think of this as an example of the lost sock problem. If you've ever spent time searching through your laundry trying to find that one missing part of your pair of socks irrationally. And then we suffer, directly related to my subject tonight, from something known as automation bias. We are inclined, it turns out, to accept things that have been given to us by machines as more authoritative than conclusions that have been given to us by humans. And we're very, very bad at questioning the outcome of a machine decision-making process. So all this is to say, humans are flawed decision makers. With due apologies to the judge, who I'm sure is a perfect decision maker. And we've seen a push across many sectors of the economy and many sectors of government to turn instead to algorithmic decision making. So algorithms, which I'll very, very loosely describe here as complex computer-created models, human-created computer models rather, have been increasingly used to make significant decisions about human beings. They're largely being used or deployed in situations where decisions need to be made at scale, meaning a lot of decisions all at once, and decisions need to be made really quickly, at speed. The logic being that algorithms are going to be more efficient for decisions that require cognition at scale and at speed. They're going to be cheaper than human decision making. They potentially might be more accurate, They potentially might get rid of some of the biases that we know about in human decision-making, and arguably they'll come up with things that are smarter than what your average human would come up with. See, for example, Watson winning at Jeopardy, and Deep Blue winning at chess. So what do these algorithmic decision makers get used in? Well, it turns out they're being used a lot already. They get used in the context of insurance determinations, trying to figure out, based on observing people's driving behavior, who should get cheaper or more expensive car insurance. There's Flo, who is not a robot, but should be. They get used for content moderation, meaning when Facebook or Twitter or any other form of social media decides to take information down, they're increasingly at least saying that they're going to be deploying algorithms to do that kind of decision-making around the kind of content that they'll take down from social media. They're being used for employment purposes. So instead of having, your biased HR sitting there and waiting for the high-class male CV to come across the door, you now have your biased HR robot sitting and doing the same thing. They're being used in the context of criminal law, both to try to determine a rate of recidivism, to predict a rate of recidivism at sentencing. They're being used to determine which communities should be subject to more surveillance and more policing. And they're being used all over the place on the internet to try to target predatory ads towards people who are most vulnerable. So, and then in a positive sense, they're being used for targeting medicine towards people who need a particular type of treatment, or they can predict what kind of disease you're going to have. So if there's one takeaway that I want you to take from this talk, it is this, right? Humans are flawed. Machines are not better. Machines are different. They're not innately better than human beings in some way. They create different problems than human being decision makers do. And this is in large part because algorithms, it turns out, are the products of human beings. So if you're interested in the topic of this talk, I highly, highly, highly recommend this book, Weapons of Math Destruction, written by, I know it's a great title, written by Cathy O'Neil, who began her career as a mathematician at Barnard. She was a professor. She left her career as a mathematician at Barnard to go work for D.E. Shaw to do quantitative work on Wall Street. Then the recession happened. She had a change of heart. She started going to Occupy Wall Street protests. And she eventually came around to this point of wanting to communicate to everybody the problem with algorithmic decision-making for those of us who don't necessarily have the mathematical background to understand it. So O'Neil characterizes an algorithm, I think really beautifully, as a model of the real world, right? When you have a computer making a decision, that computer is not going to have all the information from the real world, nor is it going to be able to fully identify what factors it needs to use in its decision. So it's a human-made model of the real world in which humans choose what the algorithm is supposed to do, right? What the objectives of the algorithm are, what should be measured to go into the calculation, including whether proxies are going to be used for factors that might actually represent what you're trying to achieve, how to weigh the different data points in that model, whether and how to check for accuracy, so how you both train the model and double check to make sure that it's working, or whether you're going to incorporate any kind of changes to the model over time. It turns out that some things are very well suited to this kind of simplification, and other things are terribly ill-suited for it. So, for example, again drawing from O'Neil's book, baseball, incredibly well suited to this kind of modeling. Because there are lots of statistics. There have been statistics in baseball since basically the beginning of the sport. There aren't proxies, right? You use what a person actually does in performance to make a decision about how they're going to act in the future. You're not using something as a stand-in for that measurement of performance. There's constant data updating, because if you've ever dated a baseball player or a baseball geek, or are one yourself, they just constantly intake the stats. And then there are other kinds of things, other kinds of decisions or systems that are terribly ill-suited to modeling. So this is not just because I'm a teacher. This is a fantastic example from Cathy's book. We have this example of a 5th grade teacher in Washington, D.C., Sarah Wysocki. She was, by all accounts, from the people who interacted with her, including her students, a phenomenal teacher. and she was working at a public school in Washington, D.C. The public school system in Washington, D.C. started implementing an algorithmic decision-making system to try to weed out some truly bad teachers within that school system. And Wasaki, to her surprise, was one of the around 200 teachers that was identified for firing. This despite the fact that her principal had been telling her she was doing a great job, her mentors told her she was doing a great job, and her students told her she was doing a great job. So she gets fired, and she tries to figure out what happens. And it turns out that the owners of the algorithm won't make the algorithm inspectable or the factors inspectable, claiming intellectual property protection for the secret sauce behind the decision-making. She, however, has a pretty strong hypothesis of what happened. So it turns out one of the factors that was going into this decision-making was standardized testing. And there was a good deal of evidence that standardized tests in Washington, D.C. of fourth graders had been subject to an enormous amount of cheating. So Wasaki's students, from fourth grade to fifth grade, went down or didn't go up as much as comparable fifth graders. And her theory for why this happened is that they actually had been given help on the fourth grade test. So this gives you an example of failures in modeling, because the algorithm making the decisions about which teachers to fire was using a smaller number of statistics, unlike baseball, which is pretty comprehensive. It was using things like standardized testing, using proxies as opposed to direct feedback or directly measurable results. Standardized testing, arguably a proxy for what you're actually trying to find out, which is this person a good teacher? And there was no flow of data back into the system so that they could figure out whether they had in fact fired the right people. The last point about this is O'Neill's term. Algorithmic decision-making often creates these kinds of feedback loops or self-reinforcing outcomes where being labeled as a failure by the algorithm makes you an actual failure, which makes the people who have built the algorithm significantly more confident that it is in fact working. Okay, so we have within the legal literature this wonderful article from 2016 by Andrew Selst and Solon Barakis, which is about algorithmic discrimination and actually looks at this through the framework of civil rights law. And they identify, in looking at what an algorithm is, what a model is, a number of things that can go terribly wrong with algorithmic decision-making. So first they point out, these things could be accurate, but be used for terrible reasons. And here we have the example of payday loan targeting to vulnerable people, or political messaging targeting to vulnerable people, depending on what side of the political spectrum you're on. Second, there's the problem of bad data. So even where you have an algorithm, the algorithm that's being used to make decisions towards what we think of as a normatively good objective, you can have the data that's going into the system be garbage in the sense that it itself is inherently filled with bias and discrimination that we don't want to replicate. So an example of this is called the garbage in, garbage out problem. An example of this problem is that you have targeted ads for people who want to go to med school being targeted predominantly, again, at men as opposed to at women, because the past data of who has gone to med school has been that more men go to med school than women do. Then you have the problem of choosing bad proxies. So again, remember with our teacher example, that's not measuring directly the question of whether she is a good teacher. And so you can have algorithms being told by humans to look at particular data points that turn out to not be directly measuring the thing the algorithm's trying to achieve, and in fact can be direct stand-ins, again, like redlining for forms of direct discrimination. So if you have an insurer or even an employer who is looking to see whether he or she is going to hire somebody, an algorithm might tell that employer that people who live closer to work are going to be better employees historically, but it turns out that people who live closer to work also happen to be white. Then you have a problem with bad weighting, which is more complicated, and I understand there may be some computer scientists in this audience, so I apologize for any misrepresentations of the technology. But bad weighting is basically like telling the model, we want you to think really hard and consider this particular fact much more importantly than this other fact, and that can also skew outcomes. We have two additional pieces of literature from the legal world. One, Technological Due Process by Daniel Citron back in 2008, and more recently a book called The Black Box Society by Frank Pasquale, published in 2015. And these pieces of literature focus on a particular type of algorithm, which is a machine learning algorithm. So a lot of what Kathy O'Neill talks about in her book, that's fancy versions of statistics. The way a machine learning algorithm is somewhat different is that it actually starts to pick up its own version of modeling, right? It starts to gather so much information that it's able to train itself towards getting the most accurate result or the most objectively targeted result towards its outcomes, and it starts to actually pick up information and teach itself over time. An example of this is language. So if you bought Siri, or you bought an Apple product and you had Siri on your phone years ago, it was a terrible, terrible natural language processor. Over time, those algorithms that speak to you as computers have picked up so much about our syntax and our expressions from the kind of expression that we have both on our cell phones and on the internet that they've been able to teach themselves how to effectively speak much more like humans. So this change happened around between 2008 and 2015. Machines started being able to be smart enough in that limited sense to really be able to speak with human beings, and we no longer yell at our phones as much. So the problem with these machine learning models is that the author, the programmer of the model, by its nature does not necessarily know what it's going to end up doing, right? It's opaque even to the person who has built it because it's going to pick up information and change itself over time. This means that not only is it extremely complex for your average person to understand or not understand, but it's also very hard for a regulator, given an existing machine learning algorithm, to go back and try to fix things after the fact, which is important for my model of governance later on. There's also this is an interesting question, and people, I think, fall on two sides of this. There's a certain randomness or acontextuality of machine decision-making. So by that I mean, you know, if you had a human who tells you, I thought about it and I'm going to deny you this loan, you know that that human is operating within a certain context, like social context of what they consider in order to grant the loan or deny the loan. And we may tie them within that social context to legal norms and sanction things that we don't like. With a machine, it may decide to deny you the loan because it's found a correlation between people who wear teal socks, which I do, and untrustworthy people when you give them money, right? And that may be something that is totally accurate in the real world. It may be the case that people who wear teal socks are really bad at repaying loans, but it's not really something that we find to be contextually appropriate for making a decision about whether to loan people money. Okay, so now I get to the actual law, with apologies for getting to the law. I came across this topic as a Fulbright-Schumann grantee. I was at the University of Amsterdam in the Netherlands and at the Scuola Santa Anna in Pisa, Italy. And this actually started from a completely different place. So I came into thinking about what I was going to do with the Fulbright from a comparative perspective, thinking I would compare US privacy law to the thing that was about to happen in the EU, the General Data Protection Regulation, and I would do so about things that gather information in real physical spaces like drones, right? So physical environment surveillance. And then I got stuck because it turns out that the GDPR contains this article, Article 22, that grants a bunch of individual rights with respect to these kinds of algorithmic decision makers we've just discussed. And there was a heated debate going on in the European Union about whether that set of rights included a right to be informed, not just that an algorithmic decision had been made about you, but in fact a right to an explanation of how that decision was made. So if you think back to the example I just gave of the teal socks, right? That would tell that loan-giving company that it would have to tell the person about whom the decision was made that the decision was made because they're wearing teal socks, right? It's far more complicated than that. It's usually not that easy to explain causally how the decisions are made, but that's the example that I'm going to give you. Okay, so this expanded from a focus on Article 22, which is a specific provision that arguably provides individual rights, to a broader focus of how the General Data Protection Regulation governs algorithmic decision-making. Because it turns out, and this is the title of the talk, it doesn't just govern algorithmic decision-making through granting individual rights. It has two forms, binary form of governance over these computer systems, and also contains a complex compliance regime that tries to get at a set of problems the individual rights don't get at. So this project both illuminates important features of the GDPR, so for those of you who didn't know that you were getting a crash course in European law, surprise, and it additionally potentially gives us a model for regulation in the United States. It additionally shows us some of the problems that can happen when you institute the kind of system that the GDPR has put in place for governing algorithms. Okay, so by way of reminder, the premise of this project is that we have algorithms being used to make significant decisions about human beings. We know that machine learning algorithms in particular are extremely difficult to regulate. I don't usually like saying that technology is disruptive or difficult to regulate, but these things really genuinely are. It's in part because of their complex or opaque nature, in part because they're constantly changing, so the version that you might regulate at one point might be different the next time that you try to go in and intervene. And as I mentioned earlier, they're very hard to regulate because it is near impossible to build in accountability post facto. You kind of have to get at them as they're being built if you want certain things incorporated into the models. And importantly, I'm not saying that what I'm about to propose should be sufficient, right? If you're, say, the owner of a company, right, you're going to be subject to fire codes, you're going to be subject to discrimination law, you're going to be subject to all kinds of laws at the same time. This is just one portion of law that I believe should be put in this space, and I think there's ample room for actual substantive requirements, say anti-discriminatory requirements for these things as well. However, I do believe this is necessary, in part because of the opacity of the use of these kinds of systems. So what do we have already? I'm not stepping into an empty regulatory space. It turns out that there is already a shockingly large body of literature in the legal world, at least, calling for different forms of algorithmic decision-making. And these vary from calls for a version of due process, which looks a lot like Article 22, to calls for more systemic transparency or accountability, including the implementation of expert boards at companies that are building algorithms for these purposes, the implementation of audits, whistleblower protection if you are a computer scientist at a company that's building one and you realize there's a significant problem, you need to have some sort of protection from being sued for revealing trade secrets, for example, by your company. Impact assessments, which in short are basically risk assessment measures that a company takes. It describes what kind of risk mitigation measures they would be putting in place. And possibly recording requirements, so requiring companies to actually sit and record the decisions that they're making, which might increase internal accountability. My first contribution to this space is to try to disaggregate the different reasons that people are calling for algorithmic accountability. So I hopefully have given you a number of examples that can serve as the basis for these more abstract reasons. In my view, these calls for regulating algorithmic decision-making stem from three different types of rationales. The first is a dignitary or autonomy rationale, which is largely focused on the rights of an individual, and I'll come back to that momentarily. The second is what I and others have called a justificatory rationale, which is really importing rule of law values into this decision-making context. And the third is an instrumental, or if you're a philosopher, a consequentialist rationale, which is that we need regulation in this space in order to prevent certain outcomes or cause certain outcomes. So bear with me, because this gets very European very quickly. As I'm discovering in my return from the EU, Americans just don't believe in dignity. The dignitary/autonomy rationale, if I start with dignity, this really does come from a lot of the discussions that are happening in the European Union about both this Article 22 right and the previous version of that, Article 15, and the predecessor to the GDPR, the Data Protection Directive. So these dignitary rationales work as follows. People are concerned about the objectification of individuals. The first objectification concern is that being subject to, and this is the one Americans hate, so if you hate it, you're in good company, is that individuals who are subject to machine decision-making are in some way inherently objectified. Right? It takes away your dignity to be subjected to a significant decision by a robot judge. Europeans buy this, largely the French and Germans in particular, less so Americans. The second version of objectification, I think, is more relatable, which is this idea that a lack of individualization in some way inherently objectifies a person. So by placing somebody into a category, say placing Sarah, the fifth grade teacher, into a particular category without allowing her to contest that category or know that she's in it, that inherently makes her an object, right? It makes her into her category as opposed to her deeply individualized person. And this relates to the concept in data protection law of the data double, which is this idea that I'm me, and the internet has a version of me. And that version of me is based on all of my browsing behavior, all the behavior that's been observed in whatever data gathering devices I carry around with me. And that thing is not me, it's an object, right? And so there's something that's dignitarily offensive about having that untouchable object version of me on which decisions are being made without letting me in some way engage with and contest and correct that object. Okay, we're out of dignity, you can relax. Autonomy is a much more understandable concept usually for US audiences. The idea behind autonomy is that we are concerned with individual freedom. And if you are a person who, say, is looking for a loan, or you are looking to decide which college you're going to go to, or you're trying to make some other sort of serious decision, and you get served up predatory advertising based on categorizing you in a particular way, or you have a loan rejection, that impinges upon your autonomy as an individual, and that largely leads to the argument for the same kind of due process system as we have in place in the judicial context. Second rationale, justificatory rationale. So this goes more to the teal socks, right? This is the rationale that says we should be in some way mandating algorithmic transparency because we want to be able to see the reasoning behind these significant decisions, right? We want to know if the algorithm's making the decision based on something that's normatively, socially appropriate or not, right? The other version of the justificatory rationale is not so much let me see your reasoning, right? Tell me why you did this, but show me that you're accountable, okay? Show me that there's something in place that is putting a check on otherwise unchecked decision making. And finally, the rationale I think most people understand and sort of where the literature is most going is this instrumental rationale. And that's the idea that with the knowledge that both human and AI decision making are deeply flawed, we should try to put in place some sort of governance mechanism to prevent the kinds of flaws that we know are going to occur with algorithmic decision making. So here again is the binary governance punchline, right? We have these three reasons for regulating. It turns out you can't get all of them from one kind of system. And I'll explain why in just a second. So I propose, and it turns out the GDPR does a version of this, a two-part system of governance of algorithmic decision-making, the first part of which looks a lot like due process on an individual level, and the second part is what's known as collaborative governance. Does anybody here know what collaborative governance is? Okay, so collaborative governance in very, very short is the idea that we use public-private partnerships in order to govern. So instead of the government, which doesn't know a lot about this technology, putting in place strict rules saying this is what you must do, this is how you must technologically design it, collaborative governance suggests instead putting in place standards and then having both the government and the private company working or private sector working together to try to come up with the appropriate rules. The obvious problem that this potentially raises is the problem of capture, right? Because if you have a government that's non-antagonistic, and it's trying to collaborate with industry, the risk that you get is that everybody's friends and everybody's friendships become a little bit too close. So what this means is that if you have collaborative governance in any space, you kind of have to have two orders of accountability. Right? The first layer of accountability is accountability over the algorithm itself, right? Trying to make sure these decisions are in some way transparent, fair, contestable, whatever it is you're looking for. And then you have to have second order accountability over the people who are deciding the rules that govern the system. Okay. So the first part, algorithmic due process, is fairly easy to understand but also extremely complicated, and this is by no means the end of this project for me. It's a series of individual rights that's based on procedural due process where a person at least gets notice and some sort of opportunity to be heard. There's another aspect of this that and I'm not the first person to come up with this. There's another aspect of this that involves what's known in the privacy or data protection literature as fair information practice principles. They're embodied in our Privacy Act in the United States. They're the core of the individual rights in the GDPR. And these are things like a right to access information somebody holds on you, a right to correct that information if it turns out that information is inaccurate, and a right to delete certain information, which gets way more play in Europe and runs into the First Amendment in the United States. Okay, so what would this achieve? Well, the individual rights portion of this would be addressing the dignitary and autonomy concerns, because instead of being told you're fired from your job as a fifth grade teacher, you would have an opportunity to contest that, and at least to get a human involved to try to assess whether the machine erred. It also addresses justificatory concerns, because depending on what kind of explanation you ask for the individuals, it could give them a sense of why the decision happened. But what it turns out it's terribly bad at is instrumental concerns. And I'll try to explain a little bit why. So algorithms are based on massive amounts of information, right? And they make their decisions at scale. If you have one individual contesting one decision, it doesn't necessarily give you a window into maybe systemic bias that would be happening across the entirety of the algorithmic decision-making process. It also, as I mentioned earlier, for certain kinds of algorithms, you can't correct them post facto. So allowing an individual to come in and say, you decided wrongly with respect to me, still means you have a faulty algorithm that's out there making decisions that are incorrect about tons of other people. Additionally, individuals are not technologically literate. They're not particularly expert at understanding sort of the euphemisms in the explanation and what that means in terms of the underlying technology. So that's the kind of thing, when it's complicated and involves expertise, that we usually hand to a different type of governance system than individual rights. So this brings me to the idea of collaborative governance. This is the idea, as I said, of at least having some public-private relationship where the government might say something like, this algorithm needs to be fair. But determining what fair means is going to be left to the technologists and the private companies to figure out in greater detail. They're not going to be left by themselves to do that, so that's my it's not self-regulation reminder. In practice, collaborative governance involves things like industry codes of conduct, industry coming up with standards, certification measures that say good quality algorithm, bad quality algorithm. And there are also informal versions of collaborative governance that include this delegation through soft standard thing that I mentioned, and involves the government taking a softer hand, such as by issuing guidance, as happens in the EU, or by doing what Ian Ayres and Braithwaite have described as responsive regulation, which is basically saying to newer companies and complicated spaces, we're going to hold off on the big guns of enforcement until we all figure out what should be happening here. Collaborative governance largely has been described as better at governing risk, better at governing fast-changing systems, so systems that change over time, better at governing technologically complex systems, but the key to it, as mentioned before, is accountability, right? You want to, if you're going to use collaborative governance to get at these discriminatory problems or these bias problems or inaccuracy problems, you want to both be creating machines that produce substantively good outcomes, and you want to make sure that that system of governance itself is legitimate. Right? That the cooperation between government and private entity is going to produce publicly acceptable outcomes. So this largely leads to a systemic perspective of accountability. It means that we're not just asking the makers of algorithms to produce an explanation of an individual decision. We're looking for what the collaborative governance literature refers to as aggregate accountability over time. So this means using tons of accountability tools for oversight over the negotiation and implementation of those kinds of public sector, private sector rules. This includes public participation, including community participation, third-party audits, expert boards, whistleblower protections, and impact assessments. Fascinatingly, all tools people have individually called for in algorithmic governance without identifying that this is a collaborative governance approach. Okay, let's skip that one. So this leaves us with a two-pronged approach, right? You have collaborative governance on the one hand, which is meant to address how you build the system and hold the system accountable within a company, and individual rights or a version of due process on the other to address these dignitary and justificatory concerns. So this is where it gets really interesting, if you're still with me. Those two systems don't necessarily melt. So in some ways they can be extraordinarily complementary, and in other ways they can be in deep tension with each other. They're complementary in the sense that we often actually characterize due process rights as producing instrumental contributions. So if I find out that an algorithm has made a decision on me based on a discriminatory factor, that in fact goes towards correcting discrimination. It might not be the best mode of doing that, but it could still produce an instrumental outcome. Individual rights can also end up giving substance to rules in a collaborative governance regime. What do I mean by this? So if I'm an individual and I come to a company and I say, you've done something unfair, and they allow me to contest it, and they realize, yes, I've done something unfair, we now have an interpretation. Who does the interpreting is a different question. But we have an interpretation that has given some sort of concrete meaning to what unfair means. And that can come back into the kind of rules that a company is going to be implementing on a broader scale. Relatedly, collaborative governance actually can do some of the dignitary and justificatory work. So a collaborative governance regime where you have oversight in the building of the algorithms or the training or the feedback can produce a deeper, more functional form of accountability, which can be both more justificatory and better respect human dignity and autonomy. But these two provisions are also deeply in tension. So if you allow people to contest individual decisions, who is going to use the contestation right? Right? It's more likely to be somebody who is a particularly complex individual who has more access to resources, who already has some sort of technological knowledge, and that allows that person to, in effect, potentially game the system, leaving only those poor people who don't understand how it works subject to this kind of uncontested decision-making. An individual rights regime can also check government's ability to kind of be more hands-off and allow for that collaborative space between government and the private sector. So, the only portion of European law that I want to give to you all today, and then I think I'm actually going to break a little bit early to get to questions, is that the GDPR, the General Data Protection Regulation in the European Union, in fact has exactly these two faces. It has both a system of individual rights as articulated in Article 22, and it has these duties that are imposed on companies regardless of whether people invoke those individual rights. The substance of those duties, including an obligation to implement suitable measures to safeguard individual rights in algorithmic decision-making, the substance of what that means is being obtained through collaborative governance, through a back and forth between regulators and private companies over time. So I think that's where I'm going to leave you today. If you have deeper questions about these parts of the GDPR, I'm happy to get into that, and otherwise I'm happy to answer your questions. Thank you.
This is fascinating. Do we have any questions? We're back in the camera back there.
Yeah. I think it's just fascinating, Margot, as you know, because I've done all this stuff myself on cognitive biases. It seems to me that it's also the case that one of the tensions is intellectual property. And, you know, I just don't know where you fitting that in, because that was the problem with the teacher and the secret sauce, and also some concern about, you know, competitive algorithms. So
yeah, so trade secrets are the big question here, right? Because copyright, you can disclose the actual code and copyright would still potentially protect it, the aspects of it the copyright does protect. But with trade secrecy, you need to keep something secret in order to have the legal protection. And this is actually a problem both in the United States and in the European Union, where intellectual property rights are considered to be also a form of fundamental right being balanced against the other forms of fundamental rights at issue here. So I think what I'd point you to, this is absolutely one of the most difficult puzzles to solve here. The policymakers who have weighed in on it so far, there's a guidance board effectively in the European Union, formerly known as the Article 22 Working Party, now called the European Data Protection Board. And in its guidelines on algorithmic accountability, it has taken the language of the GDPR where it says there's an exception in your disclosure requirements for trade secrecy, and has specifically said that exception is going to be narrow. So when data protection authorities are looking at the requirement in the GDPR that an algorithmic decision-making company release meaningful information about the logic involved in the algorithm, that is going to be subject to a trade secrecy exception, but it's going to be read narrowly. Now, in the United States, we've seen this pop up probably most heavily in the recidivism assessment context. And Rebecca Wexler has this great piece about basically the kinds of evidentiary rules around the use of trade secrecy to block the disclosure of underlying source code or other aspects of algorithms to criminal defense attorneys. It makes a pretty compelling case that those kinds of evidentiary standards need to change so that people can more effectively challenge these decisions when what's at stake is their actual physical liberty.
Discuss the tension between the federal and the state regulatory bodies in this area?
Sure. So far we have zero regulation in the United States on this. So there is no tension because it's policy void. There is a bigger picture, serious arms race that's building up right now. In case any of you have not been following what's been happening in data privacy, and you should because it's the best field, the California, in June of this last year, enacted the California Consumer Privacy Act, the CCPA. And it doesn't go into effect until 2020. But California enacting that Privacy Act, which contains nothing about algorithmic accountability, has spurred serious conversations for the first time since I've been in this field on the federal level about enacting a federal data privacy law that would in some way preempt that California Act. The idea being that a lot of the power players think they could get something more compromisey on a federal level, and in exchange what they want is for states to not be able to regulate in this area. Currently, states regulate a lot in data privacy. You have state attorney generals enforcing data privacy issues under consumer protection laws. You have specific laws in different states. Most prominently, Illinois has a Biometrics Act that's been subject to a lot of conflict. And then you have general purpose federal laws that still delegate enforcement to states' attorney generals. So in the algorithmic accountability space, the only thing that I've seen so far that have been in any way real proposals, New York had a proposal for impact assessments in public sector use of algorithms, but then turned that into a investigatory task force, so that's gone. Senator Wyden, when he proposed his data privacy bill, has a section about using impact assessments for highly risky algorithmic decision-making. And then Washington State, really interestingly, has a proposed privacy bill right now that directly imports the GDPR individual disclosure, individual explanation language from Article 22. So if it's anything like data privacy, if Washington passes that law, that will get it onto the federal discussion and have the preemption discussion about it.
I think there's someone to say. Yes, you. Yeah.
Oh, well, Liz, I'm a retired Army officer, amongst other things, but based upon your detailed research and analysis of all this, what is your gut instinct in regard to where this might be leading for the next 3 to 4, 5 years from now? What do you envision possibly where this is going? Thank you.
So I make no predictions about the technology. What I will make a prediction about is the regulatory space. I think that there is enough policy momentum, specifically in the criminal justice context, that we're really going to be seeing some version of algorithmic accountability implemented in the criminal space. What's interesting is that, and I didn't clarify this, the GDPR and fundamental rights in Europe more generally apply not just to the public sector, to the government, but also to private companies. And so the big question that's going to hit us here is we may end up importing aspects of this with respect to government actions in the United States. It's going to be a really different policy conversation when we're talking about the actions of private companies. So that's where I think the real arguments are going to be, and I'm more hesitant about what the actual policy outcome will be.
So my sense is that since the GDPR would apply to any U.S. company, right, that imports data or exports data perhaps to the EU,
Yeah.
haven't we already started, in essence, the regulatory process here? Because how practical is it really, just from a technology perspective, to create those kind of firewalls to treat sort of data
Yeah.
differently?
Yeah, so this is a different paper that I am also in the process of. So there's this idea, there are these two big theories of regulatory competition, right? One of them is the California effect, which is that you have a large jurisdiction with a big economy that starts putting in place direct regulations, and other jurisdictions start copying those regulations because the car company that's meeting the California emission standards now actually is going to lobby for regulations in, say, Illinois, because it doesn't want to be the only one absorbing those costs. It wants its competitors to also have to absorb those costs, right? So that's the California effect of exporting. The Brussels effect, which is not very clear how that's just fully distinct from California, but the general description of a Brussels effect is one where there's no de jure export, so there's no regulatory copying, but you have a big company that has so much of its presence in the EU that, as you said, it can't perform different standards elsewhere. So we've seen a lot of that, right? Like we've seen Microsoft, for example, came out very publicly and said, we're giving GDPR rights to people in the United States. And part of that is because it's expensive to try to distinguish between US persons and EU persons. And part of that is because Microsoft wants to come across as a really good actor in this space. With algorithmic decision-making, what's interesting about it is that one, this would be limited only to those companies that have that significant EU presence unless we enact US law. Two, it's one of the rights that generally hasn't ported. So even when a bigger company has said that they're going to, do the notice and access and correction rights in GDPR, they often don't bring Article 22 with them. So practically, I think you see some Brussels effect. For some reason, in this particular space, you don't see it as much. And the more interesting question to me is definitely whether you're going to start seeing the regulatory contagion, like Washington State starting to directly copy parts of the GDPR.
Thank you. Has your research touched the realm of healthcare?
In limited ways. So the health privacy space is very different from this portion of data privacy. I actually co-authored a piece recently with a professor at Michigan, Nicholson Price, who specifically writes about algorithmic decision-making in the medical context and has a couple of articles about what he's calling black box medicine. What I do think is interesting about it, when you look at, again, the bigger problems or potential problems with machine learning decision-making, when you're in the health space, the policy concerns really shift, and we start being less concerned, for example, about dignity and autonomy, at least in this sense, and more concerned with actual physical outcomes. And so Nicholson's proposed a solely collaborative governance version of this that doesn't have the right to have your doctor explain to you how the algorithm made a decision. And I'm not yet sure whether I agree with him, but I recognize that the policy balance is just very different in that particular space because people die.
As a physician, I would say that it's probably not the individual doctor, but it's the system, whether it's the hospital system or the insurance companies, that will lead an algorithm, and the doctor will follow because of the incentives.
Yep.
Time for a couple more questions, yes.
Similarly, when you move from what physicians have to use with algorithms for scribing, you move over to the judicial system. Is there similar kinds of algorithms, and I'm totally ignorant about this, that then are going to affect judicial decision-making? And I'm just thinking about Roger Stone today and wondering if any of this impacts any of that kind of work that's going on. And,
So I'll stay away from the second question, but I'm happy to talk on the judicial level. So there are already, as I mentioned, in the criminal law context, examples of these kinds of algorithmic decision-making systems being used. So, for example, and please correct me if I'm wrong because I'm not a criminal law professor. So, for example, if you have a judge listening for recommendations on whether somebody should be released, they're going to get a prediction of that person's likelihood of reoffending. And that likelihood of reoffending, that prediction, used to be something that was done by humans, and then was something that was done by humans relying on statistics, and now in many jurisdictions there's a great ProPublica study of the use of this particular company's algorithm for this, It's being done basically by these kinds of decision-making machines. And the ProPublica study, it's been contested, so I don't want to represent it as completely uncontested, but effectively showed that your best chance of getting a recommendation that you would reoffend was if you were a black male.
So I guess in any of your research, have you come across any courts, because I mean, I could see like algorithmic decision-making by a government entity maybe being evaluated, you know, under the Administrative Procedures Act or like a Matthews v. Eldridge type framework. Has any of that happened yet?
Yeah, so not to my knowledge, but I don't want to misrepresent it. I know that so this has been more the focus of Danielle Citron's work, and that was in 2008. And then Talzarski's also written a related piece about algorithmic transparency in the US context, suggesting that various government transparency mechanisms could be used to find out more about these when the government uses them. So it's not just the APA or due process. You could also use potentially FOIA, or you could use the Privacy Act to try to get a sense of what the government's actually using. At least from a policy perspective, there does seem to be an increased push to involve community members in trying to decide when to use these. And in New York has implemented, or at least a New York-based company has implemented an expert board to try to have oversight over certain algorithms used in the policing context.
I'll just take one last question. Yes.
I feel like I've seen the EU GDPR along with social media and Facebook.
Yeah.
They're really cracking down on Facebook and Twitter, aren't they? Like they're having them in hearings and different things like that.
Yeah, so the hearings are not GDPR. Google, however, just got a pretty hefty French fine under GDPR. So GDPR, in very short, this is going to be like my 3-minute introduction to European data protection law for you all. It is a regulation, which means it's directly effective in all of the member states. So it's law that was written on an EU level that's now law in all member states of the EU. It went into effect on May 25th of last year, which is why all of you Americans, speaking of the Brussels effect, got updates to your privacy policy on May 25th of last year. That was Europe. It has the significant difference between it and the previous regime is that the previous regime was a directive, so member states could implement it differently, which meant Ireland had famously lax data protection law compared to, say, Germany, which had famously strict data protection law. And this is supposed to be more harmonized. The other enormous difference is that the fines that can be levied under the GDPR are huge. It's up to 4% of worldwide revenue. And so big companies like Facebook and Twitter, well, Twitter not as much, but Facebook, Google, et cetera, are all scared of it in a way that they weren't scared of European data privacy law before.
Well, this has been absolutely fascinating. I'll be thinking about this and worrying about what they're doing to provide me. Thank you all very much for coming, and thank you.